Section 21, time for putting application in order for grant. Section 21 is important because the Patents Act and the rules are structured upon various timelines. Almost for everything that needs to be done under the Act and the rules, there is a time frame within which the applicant will have to do it. And the burden of doing the Act constantly shifts upon the applicant. There are time frames for the Patent Office to do certain things, but those time frames may be, if there is a delay in doing certain things from the Patents Act, it does not affect the application. In other words, if there is a delay by the controller in allocating the file to the examiner, it does not affect the application. That delay, there may be a delay in the grant of the patent eventually, but it does not affect the patent application in a manner, it will not affect the interest of the applicant. But if there is a delay on the part of the applicant in responding to the first examination report or the first statement of objection, that delay can actually lead to the patent being treated as abandoned. So, 21 is the provision which applies for almost every part of the patent prosecution process where the applicant is required to do an act within a particular time frame and he fails to do the act, then the patent office can deem or can assume that the patent has been abandoned. So, it is a fiction created under section 21. If the applicant does not comply with any of the deadlines, the application can be rejected, and the ground of rejection is because you did not respond within the time, we will treat it as though you have abandoned it. So, deemed to have been abandoned means the patent office assuming that the application has been abandoned because the applicant did not respond within the specified time. 21(1), the application for a patent shall be deemed to have been abandoned. This gives the power, it is a fiction, it gives the power to deem that an application has been abandoned within such period as may be prescribed. Again, wherever we see a period as may be prescribed, we will have to see what is the time given for that. The application, unless the application has complied with all the requirements imposed on him or under this act. So, this simply says that if the applicant does not comply with the requirements imposed on him by the controller or the requirements imposed on him by the act, if he does not comply with the requirements, then it will be within a time period, that is the second clause, within such period as may be prescribed. Within that time period, if the applicant does not comply with the requirements, the application is deemed to be abandoned. So, the application is deemed to have been abandoned, there is a period and the applicant has to comply with all the requirements imposed on him under the act. Now, what are these kinds of requirements? The requirements can be, the clause continues, whether in connection with the complete specification or otherwise in relation to the application from the date on which the first statement of objection to the application or the complete specification or other documents related thereto is forwarded to the applicant by the controller. Again, very critical thing to note, section 21 is a tool or a power for the controller to reject patent applications if they need not be given an order. That is the interesting part of the provision. The controller need not even give an order. The fact that he can just communicate to the applicant that you did not reply on time or you did not do an act on time, I am treating it as deemed as abandoned. The important thing to consider here is section 21 starts operating only after the first statement of objections is communicated to the controller. So, you can, if I ask you a question, the applicant refuses to take a request for examination within the stipulated period, we know that 48-month period, then what is the consequence that follows? A. Under 11B4, it is deemed to be abandoned. Under section 21, it is deemed to be abandoned. Under section 9(1). Now, in 11B4, they do not use the word deemed to be abandoned. The words used is treated as withdrawn by applicant. So, I can give all these options and I can ask what is the consequence. So, 11B4 comes in before the first statement of objection is filed. So, the 11B4 treated as withdrawn. So, this is the distinction between the phrase treated as withdrawn by the applicant under 11B4. That stage is before the statement of objection is issued. Once a statement of objection is issued, or the FER as they used to call it before, once a first statement of objection is issued, any inaction by the applicant does not respond on time, applicant does not carry out the corrections, applicant does not comply with certain requirement, the controller is going to treat it as an abandonment under 21. Why? So, the abandonment under 21 starts after the FER is issued, not before that. So, this is the important point to understand. So, if a patent is filed as a provisional specification and it is not followed by a complete specification within 12 months, it is treated as abandoned, but under 9(1), not we do not call it as section 21 abandonment. You understand? So, section 21 abandonment will come in only in cases where the FER has been issued or the first statement of objections has been issued, which tells us that there are two kinds of abandonment. There is an abandonment which you do before the patent office works on your application. They have not done any work, it is still in the dormant phase, 18 months unpublished phase. You can withdraw it, you will even get a portion of your fees back. It crosses the 18 month, it is published. Before the request for, you do not take a request for examination, it is treated as withdrawn. Still the patent office has not done any work. But when the patent office issues a first statement of objection, first statement of objection is issued after an examiner's report followed by the controller's communication. So, the first statement of objection is communicated by the controller. So, there is an examination report, the controller has considered it and then issued the first statement of objection. Anything that happens after that is treated as 21, under 21. We need to understand this well, because there need not be an order, a written order under 21, it is not required. One of the consequences of not having a written order under section 21 is that there are appeal provisions under the Patents Act. 117A, appeals to the appellate board, clause 2 lists a whole lot of provisions based on which you can file an appeal to the appellate board. When the patent office treats an application as deemed to be abandoned under 21, it is not appealable to the appellate court. You can't file an appeal. There is a policy reason for that. Why is that you can't file an appeal? Because the patent office, when it exercises its discretion, we used this word before, it has to hear the party, and discretion is where it can apply its mind one way or the other. Then we have an appeal remedy, because the patent office applied its mind in one way, the applicant can say, no, I wanted the patent office to apply its mind the other way. There is a cause for appeal, and IPAB is there, Intellectual Property Appellate Board is there, you could take the matter in appeal. Where the controller does not exercise discretion, it is an automatic process. There is an first statement of objection filed, there is a time period within which you respond, you do not respond. So, it is a procedural thing, there is no discretion by the controller. So, that is the reason there is no order required here, it is an systemic thing, it is an automatic thing. You were given 2 months to respond to an objection on prior claiming. You saw the 2 months period within which you had to correct it. You do not reply back. The controller cannot keep sending you, and the controller finds that because you did not reply back, there will not be an order. The controller can say that it comes under the language of 21. You were required to do something and you did not do within that period. Okay? The applicant did not comply with all the requirements imposed on him or under this act. So, we saw that the 2-month time period that is imposed for correcting an objection on prior publication, which is imposed by the controller, it is a condition imposed under the act. So, if he does not comply with that, then there is a period, then the act will deem that the application has been abandoned. There is a deeming provision. It will assume, it will treat the application as abandoned without any order from the controller. Because there is no discretion, we do not require an order, and because there is no discretion, this provision cannot be appealed. So, the only way is to comply with the timeline. But if you had a genuine reason, you asked your agent to do something, the agent could not do it, or there was a calamity in the town, say there were floods in the town and everything was, you could not comply with the time, then you can write to the controller to say that this could not be done because of these reasons, it was beyond my control, then it is open to the controller to consider that. But in normal cases, you are expected to do it within that particular time. So, section 21 comes into operation after the issuance of the first statement of objections, and it applies to any requirement. So, the language used in 21(1) is all the requirements imposed on the applicant, all the requirements. Now, there is an explanation to 21(1), explanation, where the application for a patent or any specification, or in case of a convention application or an application filed on the PCT, any document filed as a part of the application has been returned to the applicant by the controller in the course of the proceeding, the applicant shall not be deemed to have been complied with such requirements unless and until he has refiled it, or the applicant proves to the satisfaction of the controller that for the reasons beyond his control, such documents could not be refiled. So, when documents are returned, this constantly happens in the patent office. The controller will return a document saying you have not complied. So, you have to correct the document and refile it. So, this also includes complying with the requirements within a period, also includes refiling of documents. The only case where you will be exempted is where you can prove to the satisfaction of the controller for the reasons beyond his control, such document could not be filed. There could be a case where you have assigned the matter to a patent agent. The patent agent may either leave this country, or he may die, or he is not contactable, or he leaves the profession, whatever be the reason. In such cases, you have to tell the controller that it was reasons beyond your control. Death of a patent agent is a reason beyond the control of the applicant, that it was not done on time. So, explanation says if some document is returned, then it also applies to refiling of documents. Fact that the application has to comply with all the requirements includes refiling of documents within the allocated time. 21(2). If at the expiration of the period as prescribed in subsection 1, A, an appeal to the High Court is pending in respect of the application for the patent of the main invention, or in case of an application for a patent of addition, an appeal to the High Court is pending in respect of either the application or the application for the main invention, the time within which the requirements for the controller shall be complied shall, on an application made by the applicant before the expiration of the period as prescribed under subsection 1, be extended until such date as the High Court may determine. Now, when you have court proceedings pertaining to the invention, either the invention or a patent of addition which is related to the main invention, then you could get an extension until such date as the High Court may determine. You can get a, this is like a stay on your application. Your application is pending there and you need to do many things. There are section 21 requirements which has to be constantly complied with. But for some reason, if you have filed an appeal to the High Court, you have filed an appeal to the High Court. Now, the appeal to the High Court made sense before the creation of the IPAB. Okay. Now that the IPAB has been created, there is no appeal to the High Court under the Patents Act. Before the IPAB was created, the appeals on matters which we mentioned under section 117A(2) used to go to the High Court. Now all those matters go to the IPAB. So now the one way we can understand this is if there is an appeal pending before the IPAB and the IPAB stays the application, then it shall be such date as the IPAB may determine. Now again, like any other extension under the Act, the applicant has to make a request for extension, an application made by the application before the expiration of the period. Before the actual period expires, he has to make an application and seek an extension, and it shall be extended until such date as the High Court may determine. So, if the High Court says that the time shall be extended till we dispose this case, then that is proof to say that the timelines need not be complied till the case is disposed of. 21(3). If the time within which the appeal mentioned in subsection 2 may be instituted has not expired, the controller may extend the period as prescribed under subsection 1 to such period as he may determine, provided that if an appeal has been filed during the said period and the High Court has granted an extension of time for complying with the requirements of the controller, then the requirements may be complied with within the time granted by the court. Now, it says that if the time within which the appeal before the High Court may be instituted has not expired, normally there is a time period for filing an appeal. Now, you will find that in section 117A(4). That is why it is very hard to understand section 21 unless you understand that the appeal to the High Court was under the old Act. It should now be appeal to the IPAB. Okay. 4. Every appeal shall be made within 3 months from the date of decision, order or direction as may be of the controller, central government, or such further time as the IPAB may, in accordance with the rule made by it, allow. So, within 3 months. So, in 21(3), when we refer to the time within which an appeal mentioned in subsection 2 may be instituted has not expired, which means the 3-month period has not expired, the controller may extend the period as prescribed under subsection 1 to such further period as he may determine. So, the controller can extend the time because the time for within that period he needs to do something has not happened, or the proviso says if it is pending before the High Court can extend the time. Okay. The proviso says if the appeal has been filed during said period, the High Court has granted an extension of time, then the requirements shall be completed within the time granted by the court. So, 3, the first part says the controller can extend the time, second part says if they have approached the court and the court has extended the time, then it will be that time that is being granted. Now, all this you need to understand that 21 is very strict in its timelines. The only way you can get out of a 21 is you go to the appellate board, it says appeal to the High Court, and you get a direction from the appellate board that I need not comply with this timeline, or a direction that the time will stand extended till I comply with it, or the controller himself gives an extension. So, you should either get an extension from the controller citing certain provisions, or you should get a extension from the appellate board. Though appeal to the High Court is mentioned here, we understand it as because there is no appeal from the Act to the High Court, there is no appeal. The only way you can do is you can take, if there is a section 21 rejection, you can take that as a writ petition. A writ petition, they can be, you can argue that a writ petition is what is meant as an appeal. That is one part of the argument, but we understand this as, the way to read this provision will be to say that appeal to the High Court also includes writ petitions filed to the High Court and appeals to the Intellectual Property Appellate Board.